All right, good morning. Welcome to an oral argument session of the 5th District Court of Appeal, January 12th, 2021. We've got case number 19-2215, Rivera-Rosado and Olivero versus Florida Peninsula Insurance Company, case number 19-2215. I'm Jay Cohen, and I'm from Orange County. Joining me on the panel is Judge Brian Lambert from Marion County and Judge John Harris from Brevard County. This is being recorded on YouTube, so if you have little kids in the background, we'll get to see them on YouTube. It'll be great because we'll be the only ones looking at them from our experience. I have a 5-minute default on the rebuttal time. If you'd like something other than that, just let me know and we'll be glad to accommodate you. So that said, you may proceed.
Thank you, Your Honor. May it please the court, my name is Erin Berger. The 5 minutes that you have usually set aside is fine, Your Honor. I represent the appellants in this matter. It's a property insurance dispute. There's actually 2 cases traveling together that have been consolidated for the purposes of appeal, but we're not consolidated below. The Rivera-Rosados.
Now we're familiar with the facts of the case. Let me ask you this. There's an examination under oath that occurs before litigation commences, correct?
Correct, and it appeared.
And the ownership of the property was an issue at that examination under oath.
Correct.
All right. So then the lawsuit gets filed, and it's a year and a half before discovery is requested. What I'm trying to understand is that how is the failure of the trial court to continue the summary judgment hearing because you claim that there's discovery outstanding? How can that, under those circumstances, constitute an abuse of discretion by the trial court?
Well, Your Honor, the abuse of discretion, I believe, comes in the fact that there was a record here of the appellants trying to correct or get to the bottom of the issues to present to the court in terms of ownership and the underlying facts regarding why they obtained the policy in the name of the appellants versus their daughter and her husband. I believe they I can't speak to what trial counsel did for that time period other than to say that they did try to amend the complaint. They thought they would be able to correct the issues that way. They did try to do a motion to add parties or substitute parties. So there was some semblance of them trying to figure this out. There was attempts at discovery prior to the motion for summary judgment being filed. And then, albeit a bit far down the road into the litigation, they did try to and did hone their discovery onto the issues that are represented in Miss Rivera-Rosado's or Miss sorry, I'm getting the names confused. Adia Rivera's affidavit that says that, when they were obtaining this policy, they made sure that the representative or the agent knew that they were the owners of the property.
All right, but what I'm really addressing is our standard of review on appeal. And you would acknowledge, would you not, that it is an abuse of discretion standard in terms of the trial court's denial of additional time to conduct that discovery?
Right, and I would just say that the motion for summary judgment wasn't filed until January of 2019. The discovery that was aimed at this particular issue and the affidavits and motions that were filed in this particular issue were only served about 3 or 4 months later. This isn't a case.
The issue of ownership was on the table as of the examination under oath. So it's not like this was some new issue that popped up. This was an issue well known, and a year and a half goes by without any request for discovery. A motion for summary judgment gets filed, and then discovery requests come out. And I'm just, again, trying to get to how we find that no reasonable trial judge would have made that decision?
Again, I would say on the timeline that's presented from the motion for summary judgment forward, when the
Yeah, but then you don't get to do that. You don't get to say, all right, we're gonna pick this time frame up as of the filing of the motion for summary judgment. You've got to look at the totality of the procedural history of the case.
I do. And with that, again, they did file an amended complaint, again, albeit maybe not the correct legal procedural step to take. They were trying to take the steps to get to the point where they were able to present the facts here about ownership and why they got to where they were. There were steps that they took between the time of the filing of the complaint and where we got to at the motion for summary judgment period. Again, they filed the amended complaint. They filed a motion to substitute the parties. They filed a motion to add parties. The amended complaint was filed within a year or less than a year after they filed.
But the basis of the motion for continuance of the summary judgment and the issue that is raised on appeal is the abuse of the trial court's discretion in failing to continue or delay the summary judgment hearing, right?
Correct. And based on the record that's before us, we don't have a case as the ones that were cited by the appellee here, where a motion for summary judgment had been pending for 15 months, or there was absolutely no attempt to try to get these issues before the court, or there was, find my notes here, Your Honor. It wasn't where they had started to take discovery, but then made no attempts to pick it up again, or that there was no motion to continue even requested until a motion for rehearing after an order entered on the summary judgment. So I think the record here does show that they were trying to get there. Whether they did it the right way at first or not, they eventually got there within a few months of filing of the motion for summary judgment. So there wasn't a period of extended delay here. It was a series of activities that they did to try to get these issues before the court. They finally landed on them within a few months of filing of the motion for summary judgment. So I think given those facts and the facts that the discovery that was ultimately filed before the hearing and the motion to continue, these facts were narrowly tailored to get to the discovery that they needed to present this particular issue to the court.
Now, didn't you all indicate that no discovery was requested on the issue until 2019 because the clients didn't provide the information in a timely basis?
That was argued by trial counsel. That was one of the reasons they stated that they didn't have the discovery filed until that date. But again,
yeah, you think that's a persuasive argument?
I think in totality with the other things that they were trying to do here to get these issues of ownership and the fact that what happened when they obtained this policy before the court, I think that in addition to the other things probably helped. I think maybe it was possible that they didn't know what they needed or what they needed to show, and then when they finally got there and tried to get that before the court, they had acted diligently to that point. I think it's clear too that there just might have been an issue of what they didn't think they needed or what they didn't know they needed. And they ultimately got there. And we're not talking again about a case that's been pending for 5 years. This all happened within a matter of a year or two. And again, the record shows that counsel and plaintiffs were trying to get these issues before the court the entire time. They just weren't doing it maybe the right way at first, but they ultimately got there.
Are you familiar with the Supreme Court guidelines on how long this case or the timeframes under which it should be decided by the trial court? Are you aware of that?
Not off the top of my head, but I understand that it's probably under 2 years.
Yeah, okay. All right.
But I understand too, based on my experience, that a lot of these cases aren't resolved within that time frame, and there's a lot of discretion given, and there was discretion given here, and there were steps taken by the parties to get these issues before the court by various motions and attempts to amend the complaint and ultimately tailor the discovery to get these issues before the court. And the main issue that we were trying to get before the court, Your Honors, was presented in Ms. Rivero's affidavit, that genuine issues of material fact exist as to whether or not the statute that was relied upon by the insurance company with regard to the misrepresentations on the application would apply here, based on the cases of the Supreme Court in Almerico and the 4th District Court, I cited in my initial brief, Guarantee DeSangelo versus John Alder Life Insurance Company. The Almerico case is very similar to the facts that were presented here, in that there was an insurer that tried to rescind a policy after a claim was made, but the court ultimately decided that based on the representations of the agent and the apparent agency, or the relationship between the agent that sold the insurance policy to the plaintiffs and to the plaintiffs, created a apparent agency relationship, or at least an issue of fact as regards to the relationship between the insurer and the agent that precluded the entry of summary judgment on the basis of rescission based on misrepresentations that were made in the application. The Almerico case stands for the proposition that an agent's conduct may be imposed on the insurer who cloaks an insurance agent with sufficient indicia of agency to establish an agency relationship. And whether or not this knowledge that Ms. Rivera, had said that she gave to the agent could be imputed to the insurance company here would preclude the rescission or avoidance of the policy under the statute that insurance company relied upon here, because they had to demonstrate that had they had the knowledge that they claim they didn't have, that they wouldn't have issued the policy. But here there was evidence to suggest that they did actually have this information, or at least knowledge that could be imputed to them through their agent, that wouldn't have changed the outcome here.
Did your clients send payments directly to the insurance company?
In Ms. Rivero's affidavit, she did state that she sent payment directly to the insurance company.
And those payments were accepted?
Correct.
Okay.
She also
wasn't there an affidavit from a representative of the insurance company that said, in fact, that they would not have issued the policy had they known that the applicant was not the owner? Wasn't that part of the summary judgment evidence?
It was. There was a director of underwriter who signed an affidavit who stated that it wasn't their policy to issue these types of homeowners insurance policies to people who weren't homeowners. However, again,
it was a material misrepresentation. It wasn't just something nominal. It would have been a big deal to the insurance company.
Under this particular type of policy, that's what they claim. However, obviously, we would maintain that such an affidavit without additional discovery, which one of the things that the plaintiffs below were trying to do was take this person's deposition, was sort of a self-serving statement. And again, if the knowledge that Ms. Rivero claims that she gave to her agent could be imputed to the insurance company, then they wouldn't be entitled to rescind the policy under 627-409.
Was this an independent agent, or was this an agent simply for that one company?
I don't think the facts are that developed in the record to say, Your Honor. And that's one of the things that they were hoping to get at. Some of the discovery that was requested or subpoenas that were issued were production to these particular companies to try to get that information. One thing I did point out in my initial brief, I don't think that the point was made below, but one thing that these cases, Almerico, and actually the statute 626-324 or 342, excuse me, is that on the insurance application, the insurance company's name is prominently displayed at the top. And they said that, they filled out this application with the agent. And that's one of the things that in these cases is something that is held onto to show that there's an apparent agency relationship. So again, there's something in the record here to show that there's a genuine issue of material fact as to whether or not this agent, could be a dual.
Yeah, the agent wasn't joined on an E&O claim, correct?
I'm sorry.
The agent wasn't joined or wasn't sued under an E&O claim?
No, not that I'm aware of, Your Honor. And again, that's some of the things I think that they were hoping to be able to get to, some information that might help them amend their pleadings, maybe bring in other parties if they needed to, in order to prevent, where we are now. They were hoping to get that discovery so that they could maybe take care of these issues that we're discussing today.
Let me just ask on a procedural issue.
Yes, Your Honor.
It appears that you did not raise the issue of Florida Penn's failure to file an answer and affirmative defense in the first lawsuit in your initial brief.
No, Your Honor. Again,
And you understand that you can't raise that in a reply brief.
I do, Your Honor. The issue that I have with the argument that was made about a reply then not being filed is that that issue wasn't raised in the trial court either, and there wouldn't be a requirement, at least in the first lawsuit, for the plaintiffs to have filed any sort of reply when no answer from defenses was filed. And that's not an issue. I think that would be waived. Since they've raised that in the answer brief, I can make that argument that there was no reply required here in the first lawsuit.
But there was one required in the second lawsuit if you wanted to raise parent agency or, right?
If my argument in my reply brief that they didn't raise the issue below, that there was no pleading deficiency, doesn't waive the argument, they have cited correct case law in terms of the requirements for pleading of these issues.
So that's yes, right? That's a yes.
Yeah. It would seem so, yes.
All right.
But in the first lawsuit, there's no requirement if there's no answer from
I get you on that one. I get it.
Okay.
And again, I would just point out with my last few seconds here that the guaranteed DeSangelo case is almost directly on point with the cases here. Same issues argued by both parties. And there, the determination of an agency relationship was material because it bears directly on whether or not the agent's knowledge could be imputed to the insurance company. And that's what we're asking this court to allow the plaintiffs to present by reversal of the summary judgment here.
All right. Thank you, counsel. All right, Ms. Edelstein.
Good morning. Thank you, Your Honor. I think that you hit it on the nail on the head, Your Honor. The plaintiffs here never made any assertions until 3 weeks before the motion for summary judgment hearing was scheduled that they had been told by an insurance agent that it was okay for them to lie on the application. There's been no dispute that the application had a misrepresentation in both the ownership of the property as well as the occupancy of the property, in addition to any other questions that were asked on the application.
Well, could they have rented the property out? What if instead of transferring ownership, they simply had rented the property to the daughter?
Well, there's a different policy. This is an HO3 policy, which is for homeowners. I believe there's a different policy number for a property that's owned and as an investment with renters. So it's just a different application process. And even if it was the same application, they would have to indicate that they were not, that the property was not their primary location, which is what they represented on the appliation. And
but aren't the insurance company really insuring the property, not the people?
Well, I mean, I guess to an extent, but at the same time that you fill out an application and you answer questions related to your, I'm going to pull up the application here, related to your own ability, to pay the for the policy and other items that were in other questions in the application. And the application specifically has a signature line that talks about that everything in the application has to be correct. It says that any person—
It has to be a material breach. It has to be a material breach.
That's correct. And appellant's argument that the ownership is a mere technicality is not correct, Your Honor, because obviously the ownership of the property is material to the insurance company's acceptance of the risk. And so, for the ownership, just to say, oh, well, the name was wrong, this isn't a case where we spelled the name wrong or we got Rivera Rosado flip-flopped, it wasn't a misnomer. These people did not own the property. They they transferred the property in 2011.
Do you have any case law that supports your argument that the ownership was a material aspect of the policy?
I don't have case law. I can supplement the court if we have any, but the underwriting director's affidavit indicated that the insurance company's eligibility guidelines require that a policy be issued in the name of the owner occupant of the property. And so therefore, it would be material to the claim.
Did they accept payments from the daughter?
According to the daughter, yes, they accepted the payments. But again, that doesn't indicate to anybody that the transfer of the ownership of the property, I'm sure there's many occasions where family members or guardians or trustees will issue payments for older folks, or otherwise incapacitated, folks that own property. But simply accepting a payment from somebody with a similar last name doesn't mean that, well, gee, maybe this person now owns the property. So
Yeah,
maybe they're just doing.
I'm aware of one dad who's paying his car insurance premiums for his underpaid prosecutor's son. I've heard of that. Is that what you're saying?
Exactly, Your Honor.
But my kids have refused to pay my mortgage payment.
Ingrates.
So, I mean, typically, just because, the only arguments that were raised in the trial court were that she paid the premiums and she was present for an inspection. Neither of those indicate to the insurance company that there's been an ownership change in the property. And by the way, this isn't an ownership change. The property was transferred in 2011. The policy was incepted in 2014. So the application process from the inception of the policy was a misrepresentation. So this
did Florida Peninsula give them their money back?
Yes, all premiums were returned when the policy was voided in May of 2017, after the EUOs were.
Was that accepted?
I don't have anything in the record to say otherwise. There's nothing in the record about that, Your Honor. And to your point earlier, the plaintiffs attempted to, change the pleadings, amend the complaint, but they never brought up this issue that they told their agent that the property ownership had changed.
Was this an agent for Florida Peninsula, or was this an independent agent?
This was an independent agent. They indicated, and it's on the policy, that it was Great Florida or I think it's Great Florida Insurance, which is an agency that's not related to Florida Peninsula. And at the hearing, our counsel did indicate to the trial court that it was an independent agent and not, like State Farm, for example.
We understand it. So there was no E&O claim made.
There's nothing in the record that indicates that.
All right.
And the other issue that I'd like to discuss is the fact that when they moved for a continuance, they filed the affidavit of the daughter. The daughter's not a party to the case. Under the rule, if you're going to file an affidavit to continue a motion for summary judgment, it has to be by a party. They filed an affidavit of the plaintiff father, Mr. Rivera Rosado, but it basically says, I'm aware of a lawsuit and, I consent to what my attorney is doing. That doesn't provide the court with any of the required elements under the burden to show why the continuance was needed, which is the existence and availability of other evidence, the relevance of that evidence, the efforts taken to produce it, and that any failure to do so was not the result of an inexcusable delay. Now, they say that they had to gather evidence, but if their main argument is going to be that their agent told them that it was okay, well, then there's nothing to gather. That it shouldn't have taken them a year and a half to gather that statement. And they didn't say why it took them a year and a half since the inception of the lawsuit and the answer being filed to come forward with this argument. As indicated,
they indicated their clients hadn't got the information to them. I think that's what my recollection of the record was.
That's correct. But again, why would it take a year and a half if you contact your client and say, listen, this is what they're arguing. And we already know that that's what what Florida Penn's going to argue, because that's what their denial letter said. And we filed an answer in the one case in October of 2017. If that's going to be the theory of the case, and you go to your client and you say, listen, we need something, then they should have just spoken up right then and there and said, well, our agent told us that we could do this. That doesn't take a year and a half to come up with. So
Why
even
didn't you guys file an answer and affirmative defenses in the first lawsuit?
I think it was an oversight, Your Honor. If you look at the record in the case that we filed the answer in is the roof claim. The other water leak claim was the one that we didn't file the answer in. If you look in that one, it shows that we filed, or no, I'm sorry. If you look in the roof claim, it shows that we filed 2 answers. I think that it was supposed to have the other case number on it. And I think it was just an oversight on our part that the answer was not filed. But under Rule 1.510, the defense can file a motion for summary judgment without filing an answer. And there is case law to that effect that we don't have to file an answer before the motion for summary judgment is filed. The motion clearly set forth all of our arguments, and the supporting documentation to the motion was authenticated by the corporate representative as well as the underwriting director, and all of the evidence was set forth in the motion. Plaintiffs filed absolutely no evidence in opposition to our motion and said so at the hearing. We have no evidence. And they filed these affidavits, again, of a non-party, and then also of Mr. Rivera-Rosado that didn't really say anything, but they did admit that they were not the owners of the property. They did admit that they were not living in the property from 2011 forward, and that at the time in 2014 when they applied for the insurance, they admitted that they didn't live in the property and they didn't own the property. So the evidence shows goes to support our motion for summary judgment, where the only issues were, did they misrepresent themselves in the application process? Right, well, did they own the property and did they misrepresent themselves on the application? Those were the only issues really, because they go to both the statutory violation as well as the policy violation. And so the other issue was that the plaintiffs have no insurable interest in the property. That was our other affirmative defense. And in the plaintiffs' motions to add parties and substitute parties, all these other motions that they filed, they admitted that only the daughter and son-in-law had an insurable interest and that they were the only owners of the property. So all of the pleadings and all of the evidence that were presented in the motion and in the record proves that there was no coverage here. The plaintiffs materially misrepresented themselves on the application, and so therefore they violated the statute, they violated the terms of the policy, and they had no insurable interest, which were the 3 issues on our motion for summary judgment.
Well,
and so,
theoretically, could an agent bind the principal?
Theoretically, yes. But here, again, it's an independent agent, and again, they didn't raise the issue at all whatsoever throughout the entire case until 2.5 weeks before the hearing. So in their motion to amend, in their motion to add parties, in their motion to substitute parties, they never raised that issue. They just simply tried to change the pleadings without giving any explanation why, and other than the ownership of the property. Never raised this issue regarding the agent. Just never. It's never anywhere in the pleadings. It's not anywhere in any of the motions. And so it's too little, too late at this stage when they were required to file a reply in the one suit that we filed an answer in. They never alleged that we waived or were stopped from voiding the policy or defending on these theories based on the alleged agent's statement that they could apply for the insurance in this manner. And so they're not allowed to raise any other issues in the motion for summary judgment hearing. They're limited at that point when they don't file a reply. They're limited to only saying that they deny the claim, the allegations in the motion for summary judgment. And they didn't do that. They actually admitted that they did all of the things that we've alleged in the motion for summary judgment. So, it's hard. I can't imagine that the court, could have taken that evidence. And in any case, they didn't even, the affidavits were filed in support of their motion for continuance and not even in opposition to the motion for summary judgment. So there simply was no evidence filed in the motion for summary judgment. So,
All right. Any question, any further questions for the panel? All right, Ms. Berger?
Thank you, Your Honors. Just briefly with regard to the reference to the rule and being able to file a motion for summary judgment prior to filing an answer. Yes, that's possible. That issue wasn't raised at all below. And in that case, we wouldn't be limited to our defenses then because there would have been no answer to respond to. So that argument doesn't apply if they're relying on the rule that says that they can file a motion for summary judgment before filing an answer. Also, there was no objection below. These hearings were taken together. There was no objection below to considering the affidavits that were presented in support of the motion for summary judgment as evidence in opposition to the motion for summary judgment. In fact, that issue and the affidavits were argued by both parties at the hearing with no objection to those being considered in opposition to the motion for summary judgment. I don't believe that we made an argument in the initial brief or the reply brief that the names of the owners was a technicality. What I would point out, though, is that the insurance company did not address the substantive issue in their answer brief, didn't address the Almerico case or the Guarantee DeSangelo case at all, but maintained that the issue was that it's legally irrelevant what they told their agent and whether or not there had been some issue of representation before they filed their application. I think the cases that we've presented, the Almerico case and the Guarantee DeSangelo case, pretty much debunk that argument, because that's the issue that's squarely before the courts there, that if an insurance company wants to rescind a policy, but there's some argument that there was actual knowledge or imputed knowledge to the insurance company through their agent, then they're not entitled to rescind the policy based on those alleged misrepresentations.
Did your clients accept the return of the premiums?
I'm not sure that it's clear in the record, Your Honor. I do note that on her, Ms. Rivera's affidavit, she does acknowledge that they sent a check in return of the premiums. Whether or not they cashed it, I wouldn't be able to say, and it's not in the record. But I would also.
She didn't indicate in her affidavit, I got the checks, but I rejected them or didn't cash them. She didn't.
I mean, I
It
think
seems like that would be something she might have said if it was significant to her.
Right. I mean, I think she acknowledges that they sent back the premiums. I just don't know if what she did with the check. But here, you know, the issue that she made the payments to the insurance company, in addition to the other arguments that were made, that they gave actual knowledge to the insurance agent that helped them get this policy. All of those issues together, even though the insurance company argues that they made the payments doesn't indicate anything, but the other issues that they made the payments when they told their insurance agent that they were the owners of the property, that creates a genuine issue of material fact here that the court should have prevented the court from entering summary judgment. The record doesn't conclusively indicate whether or not this insurance agency was independent or not. The arguments of counsel at the hearing are not sufficient to establish any sort of facts. And those are the things that we were trying to be able to get, or the plaintiff was trying to be able to get below with the additional discovery. And in terms of the insurable interest argument, I mean, that the daughter and the son-in-law were the owners gives them the insurable interest, but certainly, you know, the statute defines an insurable interest as having an economic interest, and the appellants here did still have a mortgage on the property. So I think that that's, I think that that's an issue, and I don't think that the court's decision ultimately turned on that argument presented by the insurance company. It was more of the misrepresentation on the application and that fact or that argument that was made by the insurance company. And again, Your Honors, we would just request that based on the fact that there were genuine issues of material fact that remained based on the affidavits and the arguments presented by the appellants, we would request that the summary judgment be reversed and the matter remanded for further proceedings.
All right, thank you both for your argument, and we'll be